Well, good morning and welcome on this beautiful Adelaide morning here at DW Foxbarrow Lawyers. This morning I'm going to be talking about Labor's latest reforms related to the closing loopholes. So my name is Ben Duggan. I'm the director at the firm, and my chief specialty is employment and workplace relations. Just by way of some brief introductory comments, in late May 2022, the ALP formed government at the federal level under Prime Minister Anthony Albanese. But the Labor Party came to power promising a more expansionist role for the federal government. Labor in the area of IR proposed greater regulation under its policy in the last election. The greater regulation was designed to achieve some key goals that included higher wages through changes to enterprise bargaining rules, greater regulation of insecure work, including casual employment, and closing the gap between men and women. In late 2022, Labor, with the support of the Greens, was able to pass its bill to amend the Fair Work Laws, known as the Secure Jobs Better Pay provisions. And this was the third tranche of Labor's reforms. There's now been three. Labor did not stop at this point, introducing its closing loopholes bill to federal parliament last year. Key aspects of this bill included more changes to enterprise bargaining rules, greater rights for union delegates and officials, further regulation of insecure work, including the insertion of the definition of casual employment, and changes to workplace compliance requirements, including higher penalties for underpayments. The closing loophole bill, as we would all know, was split into two, with part one being passed late last year and part two being passed. Labor's workplace reforms are the most significant permanent changes to the federal industrial relations system since the introduction of its Fair Work Laws back in 2010. They clearly represent a return to past regulation, and included within that regulation, as we will see as we discuss these changes, is a greater role for the Fair Work Commission. My focus today will be the most recent of these reforms, being those contained in the closing loopholes bill. Turning firstly to the area of enterprise bargaining, I propose to go through in a thematic approach, discussing each of the key themes contained in these changes. In this particular area, as we know, Labor's earlier Secure Jobs Better Pay reform introduced a series of amendments designed to reinvigorate enterprise bargaining. The ultimate aim of these reforms was to achieve wage increases, or to use the title of the Reform Act, Better Pay, under new improved enterprise agreements. Unions could more easily initiate enterprise bargaining under the reforms. At the same time, employers' options in terms of responding to enterprise bargaining demands have become more limited, because the reforms make it harder to terminate old enterprise agreements during bargaining, and that had been used successfully by employers as a response to bargaining in the past, and it brought employees back to the modern award, which was then based on negotiations rather than the existing enterprise agreement. And new intractable bargaining provisions that enabled the Commission to arbitrate the dispute before making a workplace determination. Now, the effect of these is that the Commission was more easily able to make an intractable bargaining order and then proceed to a workplace determination. So that again impacted negotiation power of the court in terms of enterprise bargaining that's going on at the workplace. The reforms also dealt with zombie enterprise agreements, providing a sunset date for these agreements of December last year. Coming forward then to closing the loopholes reforms, there wasn't a lot of work to be done in the field of enterprise bargaining by the time of these reforms. Most significantly, the closing loopholes reforms has amended the intractable bargaining provisions to make it explicit that when the Commission makes a workplace determination, which is effectively imposing an enterprise bargaining agreement upon parties, that any term in it, other than a wage increase term, must be no less favourable to an employee or union than corresponding terms in the existing enterprise agreement. Now, in practice, this amendment that's come through these reforms ensures that union rights and employee entitlements are not adversely impacted by the intractable bargaining provisions made by the Commission. So effectively, they're setting a floor. So from the union and the workforce's point of view, they have no fear, as it were, in relation to proceeding ahead and seeking that the Commission deal with a dispute that has not been able to get to a position where there's an agreement as to an enterprise bargaining agreement. And that's a fairly significant change because what it means is that employers are going to be pretty cautious about how they deal with enterprise bargaining in the future and what they're giving up as part of their negotiations, for fear that the matter could end up before the Commission, and the Commission could be imposing terms upon them. That commenced on the 27th of February 2024. The other minor change that was made through these most recent reforms is that previously the Minister has been responsible for development and issuing of model terms for enterprise agreements, particularly in the area of flexibility, consultation, dispute resolution. We'd all know that these are three terms that must be mandated, must be included in an enterprise bargaining agreement. The reforms transfer this responsibility to the Commission, who's clearly got an enhanced workload for these three tranches of reforms. That change will come into effect from the 26th of February next year. In terms of union rights, it's clear from these changes that the union movement continues to maintain its influence despite a steady decline in union density. We all know that over the last 50 years, the union density has slowly reduced, and that's from a historical high of about 50% in the 1970s to less than 15% today. Public sector areas of education, public administration, healthcare are the most unionised sectors of the workforce today. In contrast, private sector union density is less than 10%. The future does not look positive either for the union movement, with only 5% workers aged between 15 and 19 currently members of the trade union. Labor's closing loopholes reforms have, despite the absence of union members, particularly in the private sector, expanded union rights for both union delegates and union officials, and I'll discuss how they've done that in respect of each. Firstly, in terms of workplace delegate rights, there's been some new rights created in this area. So just to explain, a workplace delegate is an employee of your business that has been appointed by a union to represent the union and potential members of the union. Workplace delegates, as some of you might be aware, did not, unlike union officials, have any rights under the Fair Work laws. The closing loopholes reforms now provide specific rights for workplace delegates. Specifically, the rights provided to workplace delegates include the following: communication, a right to communicate with members and potential members about their industrial interests; access, reasonable access to the workplace and workplace facilities where the business is operated; and training, reasonable access to paid workplace delegate training, and there's an exemption there in relation to small business. The practical effect of these rights is that a workplace delegate can spend their work time exercising their rights, for instance, to attend training other than working. In practice, an employer must afford a workplace delegate these rights, which comes at an obvious cost to the business that obviously impacts productivity. In terms of protections for these workplace delegates, the reforms include some protections to ensure that these rights occur in the workplace, and an employer is prohibited under these amendments from unreasonably failing or refusing to deal with the workplace delegates, or hindering, obstructing, or preventing the exercise of the rights of the workplace delegate. The reforms make it clear that these protections are only enlivened when an employer is dealing with a workplace delegate acting in that capacity. A failure to comply with these provisions is a civil remedy provision, such that it may lead to the imposition of a penalty for contravention of these rights, which are in turn a breach of Fair Work laws. The other interesting change is that industrial instruments will now need to provide workplace delegates' rights term. So all modern awards and new enterprise agreements include a workplace delegate rights term from the 1st of July this year. So if you're currently negotiating an enterprise agreement, it would be wise to consider inserting a term into that draft enterprise agreement. The delegate's rights term under the modern award shall be taken to be a term of a new enterprise agreement where it is less favourable than that contained in the model. So what that in effect means is that you will receive, the workforce will receive the benefit of the delegate's rights terms under the modern award if that is more generous than that contained in the enterprise agreement. So the Commission has already established a timetable for the consultation and variation of modern awards for its purpose, and it's expected to occur before the 1st of July. In terms of some key takeaways around these changes, these new delegate rights will have already commenced late last year. As workplace delegates are appointed in workplaces and employers are advised of these delegates, you may receive claims by the delegates or the union for paid time during working hours to attend training relating to their role, paid time to communicate with their members, or access to workplace facilities such as the office, telephone, photocopier, internet, and flight for their duties. Given the potential for a dispute in relation to these matters and the imposition of penalties for breaches of these protections afforded to workplace delegates, it's important for employers to prepare for this, including training their managers about the rights of workplace delegates. Because certainly in terms of managers, this is something that's going to be new to them, and something they might not expect, and something that they might not think they need to provide in response to requests. However, that's something we need to consider and escalate as appropriate within the employer. In terms of unions' official rights, so turning away now from delegates to union officials, the main issue dealt with in terms of the reforms under clothing loophole is to change some rights in relation to right of entry at a workplace. And that's in two aspects. We'd all know in terms of right of access to a workplace, there are certain basic requirements that a union official must comply with. They can only come on in respect of specific purposes. They include to have discussions with members or potential members, and the general requirement is that 24 hours notice be provided to the employer or controlling the work site of their entry. And I just make those observations in relation to these changes that have been made. So firstly, one of the reforms is to remove the requirement for union officials to have a Fair Work entry permit to attend a work site for the purpose of the provision of assistance to a workplace health and safety representative, which is an interesting change. So one of the basic requirements also is that you have a Fair Work entry permit to be able to come on site, but Parliament has decided that that won't be necessary for this specific purpose in the context of work health and safety. That might be because there's a lot of people have lost their permits over recent times due to poor behaviour. Might be basis upon which those poorly behaving union officials can come on the site without the need to have an entry permit. That's just a cynic as anything. And secondly, the reforms enable a union official to apply for an exemption to the normal requirement by 24 hours notice of entry to a workplace to investigate underpayments. There is a protection for this that's been introduced. They must successfully obtain an exemption certificate from the Commission in order to be able to exercise that particular right. In practice, these reforms enable union officials to enter workplaces for these reasons without the need to comply with the normal requirements for such an entry. So it'll be interesting to see how these are used in practice. A focus of Labor's IR policy was greater labour regulation. The target of Labor's regulation was three labour models utilised by business that fostered, in their view, insecure work: casual employment, fixed-term employment, and the use of independent contractors. In terms of the first of those, fixed-term employment, Labor's earlier better pay, secure jobs reforms had addressed this particular labour model. And as we know, the solution to that was to limit the use of fixed-term contracts to a maximum duration of 2 years. And these reforms commenced, as we know, in December of last year. Labor's more recent closing loopholes reforms have addressed the two remaining targeted labour models, being casual employment, particularly where that was utilised as a model by labour hire businesses and independent contractors. Over many years, the labour movement has targeted these labour models through the courts. The legal strategy would involve a worker engaged under a contract that described them as either a casual or a contractor, arguing that they were in practice a permanent employee. A finding of the court they were a permanent employee would provide a benefit such as leave entitlements, income support, and workers' compensation. The labour movement's legal strategy had some significant success over the years. In recent years, though, the High Court has delivered 3 critical decisions in relation to casual and contractor disputes that have provided primacy to the terms of the contract between the parties. In doing so, High Court had decided in those 3 critical cases that the person was as they were described in the contract. That is, they were either a casual or a contractor, depending on the decision, rather than a permanent employee, as the worker had sought to argue before the High Court. The High Court's decisions had effectively ended this very successful legal strategy of the labour movement. Labor's reforms in the closing loopholes reforms target these 2 labour models are a direct response to these High Court decisions. Labor's approach to addressing these models is to make the following amendments to the Fair Work Laws: to redefine the definition of employee, or introduce a new definition for that term, and amend the current definition of casual employee. In each case, as we shall see, the definition emphasises the practical reality of the work relationship as opposed to giving primacy to the terms of the contract. In terms of the new definition of a casual employee under the Fair Work Laws, the amended definition is as follows. The employment relationship is characterised by an absence of a firm commitment, firm advance commitment to continuing and indefinite work, and the employee is entitled under a Fair Work instrument contract to a casual loading or specific rate of pay for casuals. The indicia for assessing whether there is a firm advance commitment includes, as is stated in the reforms, consideration of the real substance, practical reality and true nature of the relationship. Factors which indicate the presence of a firm advance commitment include the inability of an employer to elect to offer or not offer work, the reasonable likelihood of future availability of continuing work, whether there are permanent employees performing the same kind of work, and whether the employee has a regular pattern of work. The new definition of employee also emphasises the real substance, practical reality and true nature of the relationship between a worker and the party that engages them to perform that work. In terms of the practical impact of these reforms, the departure from the terms of the contract as the primary indicator of the nature of the relationship will afford employers less certainty when they are using either of these two labour models to engage either an employer as a casual or a worker as an independent contractor. In response, business will need to assess the practical realities of their work relationship to avoid improperly classifying workers in preparation for the implementation of these reforms in August. That wasn't the only, they're the definition issues which relate to the nature of the employment. There were some other changes made as well. One of the significant ones was in relation to the issue of casual conversion. Casual conversion is something that's been an award right for some years, but it's also been included as a right under the Fair Work laws. Under the existing provisions, an employer was required to offer to convert a casual employee to permanent employment where the employee satisfied various criteria, and they include has been employed for 12 months, during the last 6 months has worked a reasonable pattern of hours, and that they could continue working those hours as a permanent employee without significant changes. An exemption exists when there are reasonable grounds not to make such an offer, and those reasonable grounds included that the employee's position should cease within the next 12 months, the hours of work which the employee is required to perform will be significantly reduced, or that there will be a significant change in the days or times of work in the future. An employee could also choose to request to convert to permanent employment in certain circumstances under the current test. Closing loopholes replaces these existing casual conversion provisions, and I must say that this is a helpful development. My experience is that these provisions, particularly in relation to those that required the employer to consider whether or not an offer needed to be made of conversion, were problematic, and they're no longer required. That aspect where the employer is required to review the casual work for an offer permanent employment is no longer required to be done by the employer. So the sole mechanism under these reforms for casual conversion is what's been described as the employee choice framework. And under this framework, casual employees may now give an employer written notification if they would like to change their employment status to permanent employment after 6 months of employment or 12 months for smaller businesses. In a response to such a notification, an employer is required to provide a written response within 21 days. And employers must comply with a range of form and content notice requirements for this response for it to be properly provided in accordance with the reforms. An exemption exists under the reforms where the employer may decline the notification to change their employment, where the employee meets the definition of a casual employment, or there are fair and reasonable operational grounds for not accepting the notification. This new employee choice pathways differs to the previous process of casual conversion. Now it is solely up to the employee to initiate the shift to permanent employment, which functionally is logical and makes sense. In my experience, quite a number of casuals who were given the option to convert by their employer at their employer's initiative chose not to do so. So it didn't make a lot of sense to continue with that particular model. It makes the entire sense for the employee, given that pathway, given that choice, if that's something they wish to proceed with, subject to criteria. With the removal of the casual conversion provisions and the introduction of this new employee-led employee choice pathway, there are less stringent requirements on employers to review their workforce and proactively offer permanent employment, which is to be welcomed by employers. Instead, employers will only need to take action where they receive an employee choice notification, and in practice, an employee can only now assert permanent employment after the job has already been ongoing, which seems a stricter test than under the casual conversion provisions, which only require a casual employee to be working on a regular basis for either 6 or 12 months, depending on the size of it. In terms of disputes, the reforms facilitate the involvement of the Commission, who are going to be working extremely busily over the next 12 months in disputes about an employee choice notification. At the first instance, the reforms require that the parties to the dispute attempt to resolve it at the workplace level. However, if the dispute cannot be resolved, the Commission now has powers to resolve the dispute, including through arbitration. The other area of change is in relation to casual employment information statements. The government seems to be big on statements. An existing requirement exists under Fair Work to provide a casual employment information statement upon commencement. The reforms expand the use of this statement to now include an additional requirement for the employer to provide it as soon as practicable after the employee has been employed by the employer for a period of 6 months. Again, there's an exception for small business, and 12 months. And then after each period of 12 months of employment. So you can see from that there's a new compliance requirement where employers will be regularly providing these statements to casual employees if they continue. In terms of coming back to independent contractors, there are a couple of changes that are significant in this space. The first is in relation to sham contracting. Now, employers who have incorrectly classified a worker as an independent contractor may be penalised for sham contracting. Currently, and these provisions haven't been used in this context that regularly, but that might change as we discuss the defences that are now available under the new reforms. So currently, a defence is available to an employee under the sham contracting provisions if they can prove that they did not know and were not reckless as to whether the contract was an employment contract rather than an independent contract when they made the offer. A new defence provides that an employer has not contravened the sham contracting provisions if the employer reasonably believed the contract of employment was a contract of services. Now, the amended defence is clearly a narrower form of defence than that currently exists. My view is that new defence implies that an employer is required to proactively consider whether the contract that they are representing to a worker as an independent contractor is truly an employment contract. I think that's pretty clear from the narrow type of the defence, which is really going beyond the normal sort of criminal elements that are applied in relation to these type of situations. My own view is that where you are going to be engaging a worker with an independent contractor who is really providing labour to your business, that it's appropriate, bearing in mind this new defence and other changes that have been made, to seek legal advice as to the contracting you're proposing to that worker. The other aspect that is significant is in relation to unfair contract terms, and there's a new framework for independent contractors to set aside perceived unfair contract terms in contracts that's been introduced that's of significance. Under this framework, independent contractors below the contractor high income threshold can now apply to commission orders to have all of their independent contractors set aside or aspects of the contract. The amendment introduces another set of broad multi-factor criteria for determining whether a contract is unfair, not limited to the respective bargaining power of the parties, whether the term is deemed reasonably necessary to protect the legitimate interests of a party, and whether the term imposes a harsh, unjust or unreasonable requirement on a party to the contract. All relevant factors as to whether the Commission should set aside or vary the term. When dealing with these disputes, the Commission may choose to proceed to a hearing, having regard to the views of the parties and the most effective and efficient way to resolve the matter. Now, in terms of how these provisions might operate in practice, previously contractors had to take their dispute to the court, which is a pretty unattractive and expensive process to be taken in relation to challenging terms of the contract. But these changes make it clear that what happens moving forward is the Commission is going to be involved, and they're going to consider matters such as fairness in terms of consideration of whether or not certain terms should either be varied or set aside under an independent contract agreement. So for those employers who are engaging workers as contractors, this certainly gives a timely and less expensive option for them to challenge those terms should they wish to in the future. The other significant change that has taken place through the closing loophole reforms is the implementation of the principle of same work, same pay. The reforms again enable an application to be made seeking a same work, same pay order to the Commission, and an application may be made by an employee, union, or host employer. The Commission is prohibited from making such an order in certain situations, and they include where the work to be performed from both employers truly for the provision of a service rather than the supply of labour. And you'll know if you were following the debate before Parliament that this was a fairly hot issue as to who was going to be captured by these provisions, or where it is not fair and reasonable in the circumstances. And again, you've got that fair and reasonable test coming into the laws. Where the Commission does make such an order, so if there's an application made, say, by an employee who's working at a host employer, and that application is successful, the effect of the order is that the labour hire employee is required to be paid at least what they would receive post agreement. So what that is doing is it's increasing effectively, in a practical sense, their base rate of pay from being covered potentially by like award to whatever the enterprise agreement is that applies to this. And that could be, depending on those enterprise arrangements, that be quite a significant increase. I must say, I regard these changes as clumsy in the sense that it's necessary for an application to be made to the Commission before an order is then made, and then the principle of same work, same pay then applied. And I can see, as I discuss in a moment, conclusion for how there might be some changes in this area. The other area where there were significant reforms under the closing loopholes was in the area of workplace compliance. There's been two significant changes made in this area. Firstly, the reforms have substantially increased civil penalties for existing contraventions that arise from under wages. And secondly, the reforms introduce a new category of penalty related to a non-payment that arises from conduct that is deliberate, which of course has been described as the wage theft provisions. In terms of the higher penalties, and what the scheme does do now is it sets up really three separate categories of penalties, much like we see in the work health and safety legislation. A general contravention, a serious contravention, and then you deal with the wage theft contraventions. So the first of these, the general contravention related to either non-payment or underpayment, now attracts a maximum penalty that is the greater of 469,000. I don't know why they don't round these figures, but 469,000 or 3 times the amount of the underpayment. And you'll see that that's a principle that carries through in relation to these contraventions. The more serious contraventions involves penalties that are almost 10 times this amount. So it's an eye-watering 4.695 million. We haven't got to the wage theft provisions yet, or 3 times the amount of payment. These higher penalties for general and serious contraventions commenced late last month. Secondly, the third category of penalty for non-compliance is the new penalty for wage theft. Now, as we all know, wage theft became a national issue several years ago with a media frenzy following the revelation of punishment for celebrity chef George Calombaris for underpaying nearly $8 million by the Fair Work Ombudsman. The punishment, which was contained in the enforceable undertaking, involved the key terms: the imposition of an agreed fine of $200,000, and interestingly, Calombaris' agreement to do some speaking engagements for the Fair Work Ombudsman. Everyone at the time, including the Morrison coalition government, agreed that the fine of $200,000 over the systematic underpayment of the workforce of nearly $8 million was light. In response, as some of you may remember, some states, including Victoria, introduced wage theft laws that criminalised the non-payment of minimum employee entitlements. The Morrison coalition government did in fact seek to introduce wage theft laws. Those did not pass the federal parliament when other changes were made to the Fair Work Enforcement. In terms of the postscript to this story, I'm reliably informed that the Fair Work Ombudsman did not require Calombaris for those speaking engagements that he agreed to do under the enforcement undertaking. It shouldn't be a surprise to anyone. In terms of the wage theft offences that have now been introduced through the closing loopholes reforms, they will apply to employers who intentionally engage in conduct that results in the non-payment or underpayment of safety nets entitlements for their employees. And what you're thinking of there is anything under the National Employment Standards or any minimum entitlements under employment law. The offence does not apply to more generous employee entitlements under a contract of employment. So an easy example of that might be an extended notice under the contract, for instance, 6 months as opposed to the minimum standard under the National Employment Standards. And if that was not paid, that would not amount to wage theft. The wage theft contravention related to a non-payment or underpayment introduces a penalty that is the greater of 7.825 million or 3 times the amount of the underpayment. And you can see that that principle of 3 times the amount of the underpayment comes through in each of those 3 categories of offences. And in my view, it's probably going to be the standard courts are looking in terms of penalty for the future. The amounts that I've been describing, of course, the actual details for which a penalty can be imposed, but I think that 3 times the amount of the underpayment is going to be the base. So unless the conduct is repeat conduct, and you would expect that in the future it's going to be 3 times. So the underpayment's 5,000, you expect to be 15,000. That's clearly the principle that Parliament seeks to introduce in relation to penalties. The other aspect, of course, that changes is in relation to the area of directors' liabilities. So, as well as the potential for the employer to be fined and penalised in this manner, there's a secondary liability for an officer of the employer, which is intended to be achieved by the extension of provisions under the Federal Criminal Code, and officers, think directors, who contravene these provisions face a jail sentence of up to 10 years. So it's not just the employer who can get penalised in relation to these wage theft provisions. It's also the directors of the company who are responsible for the underpayment who face that significant jail time. There are, and this hasn't really been picked up by the media to any great extent, that there are some safe haven provisions that apply in relation to the wage theft provisions, and these encourage employers to self-disclose conduct that may amount to wage theft, Fair Work Ombudsman. So for small employers, there's a pathway available that if they're able to demonstrate evidence of compliance with a small business wage compliance code, which is to be developed by the federal government, that acts as a shield against criminal prosecution for wage theft. And secondly, there's a pathway that enables the Fair Work Ombudsman to enter into a cooperation agreement with an employer if they disclose that they've engaged in conduct that otherwise might amount to wage theft. And that again can prevent prosecution by the Fair Work Ombudsman. Importantly, these pathways, of course, don't prevent employers from an employer or union from seeking civil penalties for the contraventions related to the non-payment or the underpayment itself. The only area where you can't take in relation to the issue of wage theft. The wage theft offences are scheduled to commence on the 3rd of January 2025. The other area where there has been some reform is in the area of industrial manslaughter. Labor's closing loophole reforms introduce the criminal offence of industrial manslaughter to the model Federal Work Health and Safety Act. So about 10 years ago, Labor, under Kevin Rudd, Julia Gillard, had developed a model Federal Work Health and Safety Act. It had done that because each of the states has got responsibility for this area of the law. So having developed the model Federal Work Health and Safety Act, the state governments then around the country introduced that into state legislation, with the exception of Western Australia. As they normally do, they went their own way. There are only minor changes that were made at the state level to that model. And in the case of South Australia, ours was largely following the model Federal Act. So in response to the indication under Labor's closing loopholes reforms to introduce this criminal offence into the model act, the local state Labor government has updated its local act to include the criminal offence industrial manslaughter. The offence applies to both a PCBU, that's we're familiar with as the person conducting a business undertaking general employer, and an officer of a PCBU. In terms of where the offence is committed by an officer of a PCBU, that occurs where there's a breach of a safety duty, and they're the three duties that you've got under the Act, and the breach causes death, and the breach involves conduct that is either gross negligence, reckless. Gross negligence is defined under the amendment as conduct that involves such a great failing short of the standard of care that a reasonable person would exercise in the circumstances, and such a high risk of causing death or serious injury or illness of an individual that the conduct merits criminal punishment for the offence. The term reckless is defined by reference to conduct which involves their knowledge of the risk to an individual of death or serious injury being substantial and unjustifiable in the circumstances. Okay. Turning now to some of the other changes that have been made. There has been some stronger protections introduced in relation to discrimination in relation to employees that have been or continue to be subject to family and domestic violence. Those provisions have been picked up in closing loophole reform that are welcomed by everybody. The other significant change that has probably attracted more media attention than anything else about these reforms is, of course, the right to disconnect. Now, this was a last-minute change to the closing loopholes reforms, was something that was pushed pretty hard by the Greens, and really was, it seems clear, was part of their agreement to the other reforms that were introduced through the closing loopholes reforms. So this right to disconnect has been introduced through the reforms. To my knowledge, it wasn't something that was contained in Labor's policy that took to the election, but it's certainly been an issue that's been pursued by the Greens, in particular senators, one of the local senators here in South Australia for some time. The right to disconnect has been inserted into two different locations. Firstly, as a general right to disconnect under the Fair Work laws, and secondly, as a model right to disconnect, which is to be inserted into modern laws. In each case, the right to disconnect shall entitle an employee to refuse to monitor, read, or respond to contact from an employer or third party, think a client, outside the employee's working hours unless the refusal is unreasonable. Now, importantly, this will act as a right rather than a requirement, meaning an employee may respond or connect out of hours if they wish. So it's not a prohibition on connecting. The way in which it works is the employee can exercise that right not to connect if they choose, and it's subject to the reasonable test. And a critical aspect of this, which no doubt is going to be the subject of litigation in the future, is whether the refusal to connect is unreasonable. Now, this is similar to the criteria for reasonable additional hours already contained in the Fair Work laws. So whether a refusal to respond is unreasonable will be determined by a multi-factor test, including an assessment of the reason for the contact, the method of contact, having regard to the level of disruption that contact might cause, the nature of the employee's role and their level of responsibility, and the employee's personal circumstances, including family and caring responsibilities, and whether the contact is required under a law of the Commonwealth, state or territory, and the extent to which the employee is compensated to remain available during working hours. So I think that, to me, the critical issue is going to be whether there's an intention to reward the employee staying connected in some way. So it might be that they are paid a standby allowance, something similar. And it seems to me in those circumstances where there is some sort of consideration for being ready to be connected as required, that is probably going to get around the issue that employers might fear in terms of their employees not connecting where they need to in an urgent situation. Now, this might arise. The obvious example is, having acted for clients in the medical sphere for many years, the obvious example is when you've got doctors who are standby, ready to come in emergency situations, particularly if their work is attached to the maternity wing of a hospital. Now, you obviously need those doctors, nurses and the like to be able to come in and be on standby to be able to come in those situations. Now, the right to disconnect doesn't really practically work in that situation. You simply need people to come in and as you might expect, deliver a baby. So I expect that that's how employers are largely going to get around these provisions. There's been a fair bit of scaremongering around this. I do agree with the Greens' position is that you wouldn't expect a lot of disputation about this issue, particularly, as I say, in circumstances where there's some compensation for being available. There is an ability, though, for disputes to occur, and in terms of that, again, the expectation is that these disputes are dealt with at the workplace level, but again, if the dispute doesn't resolve at that level, an application can be made for the Commission to deal with the dispute. The Commission is empowered to make orders to stop refusing contact or to stop taking certain actions, such as disciplining the employee for refusing contact. In terms of contraventions of those orders, it's a civil penalty contravention, and the federal government has also introduced a new bill to prevent employees from facing criminal penalties for contravening such an order, apparent mistaken inclusion in the reports. I thought I'd finish talking about the future of work and where we're going in terms of these reforms and future reforms. I think it's pretty clear, and this was really heightened by COVID, that we are moving to a situation of bespoke work. And there was a report done by the CSIRO that dates back to 2016, and bear in mind this was pre-COVID, which was entitled Tomorrow's Digitally Enabled Workforce. And it noted that the following changes occurring in our workforce: increased technological change, rapid growth of the freelance employment market, co-working facilities from home. It's interesting that some people will describe working from home as a result of COVID, but certainly there's a lot of it obviously occurring during that period. However, as far back as 2016, the CSIRO was noting that as a significant trend, and that trend has certainly occurred with COVID. My own view, particularly due to the current labour shortage, is that employers will more and more have to accommodate desires of workers, which include bespoke work, including working from home. So what might some of these future changes look like? There's already been a discussion about working from home and whether that should be a right under Fair Work laws. There is, of course, already flexibility provisions under the Fair Work laws, and certainly my view is an employee could apply under those provisions to seek to working from home in any event. So there's no need specifically for a right, but that's certainly on the agenda. Senator Pocock has made it clear that she's going to continue to push for that in the future. The other thing she's indicated, which she has, and she's the one who's on the right to disconnect provisions, but she's been talking about for a long time a 4-day working week. And that's what you would expect her to continue to push for. Again, that's something that you could apply for under the current flexibility provision of the Fair Work laws, but what she's talking about is having a general right under the Fair Work laws for those changes. I mentioned in relation to the discussion about the same work, same pay principle, I thought the need to apply to the Commission was somewhat of a clumsy process. I think the next step in relation to that, and what we might see some pressure from union and labour to pursue, and as well as the Greens, is that that principle is simply enshrined as a right, as opposed to having to go through a process of applying to the Commission in order to be able to achieve the same work. So what I mean by that is that it then becomes a workplace right. That is that if you are working under a host employer's arrangements and you're working at a host employer's premises, that you don't need to go on to the Commission, that they simply need to pay you according to the enterprise agreement that applies to the workplace. And I think logically that's where the next step you expect goes, because the current process is somewhat clumsy unless you've got a highly sophisticated union who are able to make that application, put forward the evidence before the Commission and justify that principle and apply it. It's not likely to happen across the board. The other area is that on the from the point of view of business, they have been complaining that all of these changes are taking away a degree of flexibility, and that in recognition of the greater flexibility that workers are seeking, that there also need to be changes made, in particular in relation to the nature of engagement. One of the areas New South Wales Business Council has suggested should occur is that there be a new definition of part-time employment. Now, in relation to part-time employment, as some of you may know, under most awards, what you're required to do is you're required to set days, hours, time, work. And if an employee works outside of those hours, they're of course getting paid very much or overtime, which can be quite significant. So what the New South Wales Business Council has suggested is that there be some new form of flexible part-time arrangement, which you might find in some enterprise agreements, where an employer can ask an employee to work, and if they agree to work up to a certain number of hours, then instead of paying those penalty overtime rates, the rates be set at something like 10%. At least that's their proposal, which seems a sensible approach to take. You might find in your workplaces that can be an issue. You might have somebody who works part-time 2 or 3 days a week, and one of their colleagues might be sick on one day for whatever reason. They might be open to doing extra hours, but it is expensive when you're having to pay the overtime on top of their fixed hours. And certainly the concept of paying a penalty limited at 10% for a certain number of hours does have a level of attraction to it as we're moving towards a more flexible workplace. By way of summary, the reforms that we've seen through the closing loophole reform finish off the third tranche of reforms. These are the most significant reforms in over a decade. Aims such as increasing wages and gender equity are well-meaning. The non-stated aim, though, is to seek to provide greater reference to trade union movement through changes to enterprise bargaining rules and representation rights. It remains to be seen whether these well-meaning aims achieve their goal or simply impose more red tape for employers who face the prospect of greater scrutiny of their decisions as to matters such as whether to provide flexibility or convert a to employee determined by permission. The costs for employers and compliance mistakes, in particular paying incorrect employee entitlements, has risen sharply through these reforms, including the introduction of wage theft for those employers who deliberately engage in such conduct. For employers, the time seems to be right to review contracts, policies and practices to ensure that they are compliant with these reforms. That's the end of my talk. I'm more than happy to take questions if anyone's got any questions at this stage.
Hi. Yeah, I did flag in my response to the RSCP.
Yes.
I'm in a situation where the organisation I work for is a multi-state organisation headquartered in Sydney. So I was really just curious to see what your thoughts were about the industrial manslaughter provisions and how that would apply to, I guess, from a state perspective within South Australia for a business where technically the offices are domiciled elsewhere.
Sure. So in a situation where the employer is domiciled in the state, then my view would be that they face the potential, that is the directors of that company, face the potential that they will be penalised if there's a contravention by them of any of the provision under Work Health and Safety Act. So I think that's the risk that they face, even though they're based in the state.
This is obviously very specific to us, but would wage count if an employee has worked but hasn't provided their paperwork, or like their employee documents to the business, or their documents may have been lost by the manager?
Sure.
Essentially,
Fortunately, wage theft provisions haven't started yet. But in the future, it would be appropriate to get the documentation in order. But look, potentially, they could apply to that situation.
would it be even practice to formalise something where you would say that a person can't be rostered on or can't start work until that paperwork has been received?
Sure. I mean, yes, that would be correct. I mean, I'm conscious that sometimes when an employee might start on a particular day, work might not have been completed at the time they start, but certainly as a general rule, that would be correct. It would be appropriate to ensure that paperwork is completed before any work starts.
Great. So just one other question, just really quickly. In terms of the, we do have quite a large number of casuals that might be impacted by the ability to request to.
Yeah, sure.
Obviously, if the onus is on the employee, is there structure or framework in terms of how we notify them of their right to be able to request that? Is that something where we could potentially put it on a SharePoint page,
Sure.
links, or do we have to email,
Sure.
potentially 5?
Sure. Well, you can do all of those things. The other intention of casual information statement is that they're given at times that then trigger the employee to think about applying for a right to convert.
Yeah.
So certainly if you're applying those obligations in relation to privilege statements, that would be sufficient in relation to compliance. But if you decide to do it in other ways, well, that's certainly an option for you. You can have a policy on the intranet or the like.
Yeah.
So
But we would still be required to
correct. Still
notify them every 6 months.
You're still required to follow those statement obligations.
Thank you.
So consider myself to run a small business. I have 8 employees, but I run a labour hire business. We're on both Commonwealth and state government labour hire panels.
Yeah.
We have 65 on-hire casuals across Australia. Probably 10% of those would be purely defined as independent contractors with their own proprietary limited companies.
Yeah.
There seems to be quite a lot of confusion around the casual conversion. A lot of our federal government contracts are 12 months with up to full extension, which is 3 years. What happens in situations like that protect us? Because although I only employ 8 permanent full-time employees within our office, we're not defined as a small business under any of the legislation or rules.
Sure. So and there's a few issues there, but in relation to the fixed term employment issue, there is that 2-year limit. However, there's a number of exemptions that apply, in particular around federal funding, and it may well be that those exemptions are applicable to your business, and that might be a simple out for you, which enables you to have a fixed term contract beyond the 2 years. And in terms of the annual conversion issue, it seems to me one of the pleasing aspects of the reform is the change to move away from employers having to consider it to having it driven by employee choice. And that, in my view, will lead to a simple process, and that should sort of business like yours, where you've got a number of casual employees and you don't need to consider the issue unless it's raised with you through a notification, and then you can consider the normal reasonable test your business and whether or not that's something you need to offer. You can knock back, as the case may be. And I suspect that in most cases you're probably going to get a knock back notification on receipt. The other interesting aspect is that I haven't, from my experience of assisting employers, found that there's been a rush of people applying for casual conversion over the last few years. So if you take away the need for the employer to consider that issue and then consider whether they need to offer it if it's required, you might find that you don't get a lot of requests for people that is then supplying you with a notification wishing to convert, because of course one of the issues which is really discussed in every great detail, which employers understand though, is that of course you don't get the hiding in it, which from my experience, including at home with my young children, is very unattractive to drop the 25% loading by converting. So And look, a lot of employers have introduced that.
Just on that point where, they remove the loading.
Yeah.
There are test cases at the moment where employers have taken on, let's say, a trades assistant,
Sure.
which is being paid at say $30 an hour, and then after say 12 or 18 months, they've said, hey, how about doing an apprenticeship? But instead of dropping that person from their trades assistant salary down to a first year apprentice, they've had to pay their first year apprentice at the existing rate because there's provision that says they're not allowed to.
Yeah, well,
reduce the salary.
that might be specific to that situation, but certainly generally, if you're talking about employee performing a role under the award outside of that apprentice situation, there is a dropping of the 25% loading. And I can tell you that larger employers have been adopting such strategy. I'm aware that Woolworths and Coles, for example, have been adopting that strategy and converting their casual workforce to permanent part-time in preparation for these laws, and other employers have been doing the same thing. The effect of that, of course, is that employers are using their loading. And certainly, my lad who works always held off for about 18 months. They forced him to become permanent part-time. But it certainly was a new experience for me, because certainly when you're studying, the normal expectation is you're doing casual work, but these days the young kids are getting offered apprenticeships, which is certainly a change, and obviously entitles to any leave and other benefits as a permanent employee. So that's a welcome development. But I think that certainly my experience of speaking with younger people is that they in particular don't want to change over to permanent. Obviously, it's going to be different. If you're looking at buying a house, so you're at a different stage in your life or other stage in your life. So it really depends on the person, but a large percentage of the workforce are young people who frankly, in my experience, don't want to convert. So I don't think there's going to be a rush of notifications that employers receive for conversion.
You mentioned a model term on the right to disconnect in the instance. Will that be, I assume, for enterprise agreements as well?
Yes. Yeah. The model term will be for insertion into awards, and then the enterprise agreement, you can choose to negotiate a different model term to that contained in the model award. But I frankly can't see that happening, because in a situation where the model term under the award is more generous to the employees or the unions, then that will apply over what you agree for your enterprise agreement. So it doesn't say that there's going to be a lot of point. I suspect what's going to happen is much like the dispute resolution, the other compulsory terms, mandatory terms, that the right to disconnect be like those where you just cut and paste. You adopt the same provision, and that way, when you get before the commission approval purposes, you can say, well, we've adopted the right to connect term from the relevant one award.
And is that do you have a date for that? Is that just July? Oh, yeah, nice. Thank you.
So that model term will go into the one awards from the 1st of July. So really from that date, you'll be able to understand what it is that I would have thought goes into your enterprise agreement. There might be some reason why you want to change it in the workplace, but I would have thought probably more likely to do that.
Yeah. Sorry, you talked about potential standby allowance. Do we know a reasonable allowance might look like in terms of like would it be a percentage of a particular wage, or is it like just tack on $50 to someone?
Sure. Well, I mean, look, the way in which the standby allowance operates generally is that you might be paid a fixed amount to be on standby, and that's generally a small amount. It might be $20 a night or $50 a night. And then it works on the basis that if you do get contacted, so if you get contacted asked to come in and deliver the baby, well, you get paid your normal wage plus a penalty over time in that situation. But if you just got somebody there where you're requiring them to be available to be connected as required, then it's probably going to be a relatively small amount in that situation. It's only when the contact occurs that there might be an overtime rate or something that gets paid. And certainly, I think if you're taking that approach, I would have thought you're largely going to be getting around the see a problem with this right to disconnect. Because once you're doing that, it then becomes, it seems to be unreasonable for the employee not to connect in those situations because they're getting paid. All right. Thank you again for coming in. And hope you enjoyed the session and look forward to seeing you soon.